Oh, you know what? And I also didn't give you the booking number for the 2
If you have, Judge, that's great. If you don't, that's okay as well.
You're fine. If anyone has a problem with it, let me know. It's my own fault. Okay, so Mr. Interpreter, have you been sworn in?
Yes, Your Honor, I have.
And do you need his name?
He had already announced.
Yeah, okay. All right, and state if we could get your appearance.
Yes, Your Honor. Joseph Mikazuski for the state.
Mikazuski. And counsel for the defense.
Yes, Your Honor. Kaylee Lamphere on behalf of the Public Defender's Office.
Lamphere.
Yes.
Lamphier?
Lamphere.
Yeah. I was close.
You were
I was trying to make you fancier. Lamphere is pretty fancy already. Okay. So we're here for Mr. Reynaldo Saclovaverde.
Yes, Your Honor, if I could kindly request that he put the headphones on, Judge.
We're on it. Can you see us? How did you know he didn't have them on?
Yes, Your Honor, I have visual.
Oh.
I can actually even control the camera, Judge. They give me that much power.
Just remember, power corrupts.
Yes, Your Honor, I'm very well aware.
We have plea numbers on our website.
Okay. Mr. Interpreter, this is case 2022 CF 578.
Thank you, Your Honor.
You're welcome. I was going to try to say it in Spanish, and I slipped to French because of Miss Lamphere. I just thought she was French. All right, sir. We're here today. You have been charged with false imprisonment and domestic violence battery. And Mr. Interpreter, is it a simultaneous interpretation?
Yes, Your Honor, he can hear me through the headsets. Everything that's being said in the courtroom, I'm interpreting in a simultaneous mode.
Simultaneous, excellent. Then I will not pause, but I will still continue to.
I'm sorry, Judge, you have to do it over
Slowly.
loudspeaker because his victim need interpret.
Oh, okay. Well, stick a pin in that, Mr. Interpreter. We have a victim present who needs your services as well.
No worries, Your Honor.
Okay, so we're going to start all over. No, it's okay. Mr. Sique Valverde, you have been charged with false imprisonment and battery domestic violence.
Señor Valverde, usted le acusan de detención ilegal y agresión violencia doméstica.
The court finds probable cause.
El tribunal determina que hay motivo fundado.
And who do we have present here as a witness?
¿Quién tenemos presente como testigo? I'm sorry, Your Honor, if I could ask her to come closer to the microphone, please. Señorita, por favor, acérquese al micrófono, alce la voz que no se le escucha.
Erika del Rocío Gallegos Quinde.
Despacito, por favor.
Erika del Rocío Gallegos Quinde.
Erika del Rocío Gallegos Quigne.
Ajá.
And your relation?
¿Y cuál es su relación?
Él es mi pareja, convivíamos.
He's my partner, we live together.
If you'll raise your right hand.
Por favor, levante su mano derecha.
Do you swear or affirm to tell the truth in this matter?
¿Usted juro afirma decir la verdad en este asunto?
Sí.
Yes.
You can put your hand down.
¿Puede bajar la mano?
State questions?
Fiscalía, ¿tiene preguntas?
Hello, ma'am. How long have you known the defendant?
Buenas tardes, señorita. ¿Cuánto tiempo lleva usted conociendo al acusado?
12 años ya.
It's about 12 years now.
And do you still live together today?
¿Usted aún viven juntos en el día de hoy?
Sí.
Yes.
Do you have fears of him being let out on pretrial release?
¿Usted teme de que él lo suelten bajo condiciones de libertad provisional?
No lo entiendo cómo.
No, I don't understand. What do you mean?
If he's released from jail, would you be afraid of him coming back to the home?
Si él lo sueltan de la cárcel, ¿usted tuviera temor de que él regresara a la casa?
No.
No.
Do you wish to have contact with him?
¿Usted desea tener contacto con él?
Por mi hijo, sí.
For my child, yes.
Right, but he lives with you, so I'm asking if you have fear of him living with you or being in contact with you.
Sí, pero él vive con usted. Por lo tanto, le estoy preguntando que si usted teme que él regrese a tener contacto con usted específicamente.
No.
No.
Okay. That's nothing further, Your Honor.
Nada más, su señoría.
Defense?
Just for,
Defensa.
Remember, let him interpret even when you know what I'm saying.
just for clarification, Your Honor, were we appointed in this case?
Su señoría, simplemente para aclarar, nosotros fuimos asignados en este caso.
You were not. Do you wish to be?
No lo fueron, lo desean hacer.
Yes, Your Honor, if Mr. Seco Valverde wants us to be appointed.
Sí, su señoría, si el señor Valverde desea que seamos asignados.
No, I don't have to make sure. I was being glib. So you're appointed. I don't know that I'm not going to give him the chance to say no.
Okay. Yes, Your Honor.
Usted será asignado, no importa que él lo rechace. Sí, su señoría.
No questions from the defense, Your Honor.
No tenemos preguntas por parte de la defensa, su señoría.
And I believe he qualifies for pretrial release.
He does, Your Honor.
Creo que él reúne requisitos para el Departamento de Libertad Prejuicial.
It's hard, I know.
Sí, su señoría.
He does, Your Honor.
Él reúne requisitos, su señoría.
So the court will grant pretrial release and order no hostile contact.
Entonces el juzgado va a emitir libertad bajo Departamento de Libertad Prejuicial y ordenando contacto sin hostilidad.
Thank you, ma'am.
Gracias, señorita.
If I may, Your Honor,
Si me permite, su señoría.
Wait, hold on, I just released her.
that's fine. It is as it pertains to the pretrial release condition. This is the same offense that pretrial release said that you had to have a monetary amount with it because it's a crime of violence. So along with pretrial
señor-
release.
Su señoría, el Departamento de Libertad Prejuicial anteriormente había indicado que como es un cargo de violencia, se necesita añadirle una fianza al programa de libertad prejuicial.
I don't think Orange County is requiring that.
Gotcha. No problem.
No creo que el condado de Orange lo exige.
You guys. All right, thank you, sir. Wilson Rojas Jimenez. Okay, this I see. Come on in. Mr. Witness, do you need an interpreter?
Sí.
Señor testigo, ¿necesita usted un intérprete?
Okay, so you're not going anywhere, Mr. Interpreter. No
Where is your
headsets
honor?
for you. Mr. Rojas, are you Mr. Rojas Jimenez?
Usted es el señor Rojas Jiménez.
Okay. Mr. Rojas Jimenez, you have been charged with battery domestic violence.
Señor Rojas Jiménez, usted lo acusa en el cargo de agresión, violencia doméstica.
I see he qualifies for pretrial release.
Veo que reúne requisitos para el programa de libertad provincial.
We have a witness. Sir, if you'll raise your right hand.
Tenemos un testigo presente. Caballero, por favor, levante su mano derecha.
Do you swear or affirm to tell the truth in this matter?
Usted juro o afirma decir la verdad en este asunto.
Lo juro.
I swear.
You can put your hand down.
Puede bajar la mano.
I'm appointing the public defender.
Voy a asignar las oficinas del defensor público.
State any questions.
Fiscalía, ¿tienen preguntas?
Hello, sir. How do you know the defendant?
Señor, ¿cómo es que usted conoce al acusado?
Soy su esposo.
I'm his husband.
And do you have any, or do you wish to have contact with him?
¿Usted desea tener contacto con él?
Sí.
Yes.
Would he be staying with you if he's released from jail?
Si a él le dan la libertad de la cárcel, ¿él fuera a vivir con usted?
Sí, claro.
Yes, of course.
And do you have any fears of him doing so?
¿Y usted teme que él vuelva a vivir con usted?
¿Me puedes repetir la pregunta?
Can you repeat the question?
Sure. Do you have any fears of him coming back and staying with you if he's released from jail?
Claro, ¿usted tiene algún temor de que cuando él lo suelten, él regrese a la casa a vivir con usted?
No.
No.
Nothing further, Your Honor.
Señoría.
Nada
¿me
más,
per-
su señoría.
Señoría, ¿me permite decir algo?
Your Honor, would you allow me to say something?
No, not yet.
No, No todavía.
Defense?
Nothing at this time.
Defensa, nada en este momento.
We got one more. Got one more chance. What is it that you wish to say, sir?
¿Qué es lo que usted desea decirme, caballero?
Que el problema, que nosotros no tuvimos ningún problema de agresión física. Es que
We didn't have any issues with physical aggression.
los policías solo hablaban inglés
The officers only spoke English,
y no entendían lo que nosotros le estábamos explicando.
and they were not understanding what we were explaining to them.
So I don't need to hear that for today.
Yo en el día de hoy no necesito escuchar eso.
We just needed to know if you were afraid of him.
Solamente teníamos que percatarnos si usted tenía algún temor.
No,
Unless there is any
No.
objection from either side, the court will order the pretrial release.
A que no sea que existe una objeción por alguna de las partes, el tribunal va a emitir libertad con libertad provisional.
Judge.
No, Your Honor.
No, that was Mr. Interpreter's fault.
Sin objeción, su señoría.
Oh, and speaking of Mr. Interpreter, case number 2022 MM388.
Thank you, Your Honor.
You're welcome. All right, thank you, sir.
Muchas gracias, caballero.
Any conditions, Your Honor?
No hostile contact will be the condition.
Condiciones de contacto sin hostilidad.
Ms. Lampier, did you say something?
No, Your Honor.
So it was,
I hear it?
pretrial release with no hostile contact.
Correct. Is somebody saying something? Can you all hear that voice?
I believe he was interpreting just that there was the condition of no hostile contact. And then, I don't know after that.
I think it's back in the other room.
Yes, Your Honor, the interpreter can hear it as well.
Okay,
That
well,
wasn't
as long as we're, thank you for being the only one who admitted they could hear something and not me thinking that I'm only hearing voices.
No, if I can hear it over my connection, then you can certainly hear it.
Although I'm surprised you didn't say, what voices? All right, Mr. Miguel Medina Mercado?
I'm sorry, Your Honor, could you kindly spell that last name, Miguel Medina, and what's the other last name?
Mercado.
Thank you very much, Your Honor.
It doesn't appear that there's anyone here for this case, so
Por favor, póngase los audífonos, caballero.
And Mr. Interpreter, while he's putting the headset on, this is case number 2022 CF 593.
Thank you, Your Honor.
Welcome. All right. We're here today, Mr. Medina Mercado. You have been charged with possession of heroin. Wait a minute, hold on. I think there's multiple cases, right?
Yes. Two cases.
Oh, thank you. Do you need to know the second case number, Mr. Interpreter?
Yes, Your Honor, if you wouldn't mind.
Okay, 2021 CF 1291.
Thank you, Judge.
So you had, the first case, you've been charged with possession of heroin. The court finds probable cause, and the court is inclined to issue a bond in the amount of $1,000. State?
Yes, Your Honor. I don't know, okay.
I know. See, now we got used to waiting, and now he's doing the headset. We can't win, people.
As it pertains to this case, the state would have no objection.
No objection, Your Honor.
We're like owled. We're waiting, Mr. Interpreter. And in the second case, there was a failure to appear. He's charged with a failure to appear, and the original offense was aggravated assault with a deadly weapon. The court is inclined to have no bond in that case. And the court is going to appoint a public defender. State anything?
Further, Your Honor.
Defense?
No, Your Honor.
Okay, thank you. All right, so I think, oh yeah, Mr. Interpreter, anything else for you?
I don't know, Your Honor. Would you like me to sound to make sure there's no other witnesses that require the interpreter?
Ah, how smart are you? Yes, please.
Certainly, Your Honor. Su atención, por favor, si hay alguna otra persona presente que va a necesitar los servicios del intérprete, por favor, alce la mano en este momento. Your Honor, I don't see any hands on my vantage point. Your Honor, can you confirm that for me?
I don't see anything. State, can you, anybody got their hand up over there?
No, Your Honor.
No, I mean, over there, they're the witnesses. Yeah,
Yeah.
okay. All right, no, all right. Muchas gracias. A la orden.
Thank you so much, Your Honor. Have a great afternoon.
I'm hanging up on you. Okay, all right, done. All right, is this Mr. Nicholas Smith?
It is, Your Honor.
And counsel, your appearance.
Courtney Daly on behalf of Nicholas Smith, covering for Ken Yulo.
All right, thank you for being here.
Of course.
So, Mr. Smith, hold on, in case number 2022 CF 596, you have been charged with possession of a concealed weapon, a firearm by a convicted felon, and possession of cannabis less than 20 grams. The court finds probable cause as it relates to, bear with me, I'm juggling here. As it relates to count one, the court would be inclined for a $10,000 bond. And as it relates to count two, the court would be inclined to do ROR. And then as it relates to his prior, as I understand it, he is out on bond for prior offenses.
Yes. I
And,
may be heard when you get a chance.
I'm sorry?
They said if I could be heard when you get a chance.
Well, let me go on the record as what I believe them to be. You can correct me and respond to that.
Okay.
How's that sound? Charges, his prior counts are charges, possession of a firearm by a convicted felon, carrying a concealed weapon, and driving while, DWISR, driving while suspended license, revoked as a habitual offender. Okay. Is that your understanding?
Yes, that's my understanding.
Okay,
Is
what
that's
did you
his
want
current
to,
charge.
what did you want to be heard on?
So we're of the position that there isn't probable cause. The state needs to prove knowledge, and there's no way he could have known there was a firearm under the seat of a car that he wasn't driving nor responsible for. He was simply a passenger. But if the court does find probable cause, I would ask for you to take those facts into consideration in revoking his bond. The court does have discretion to revoke his bond and set it at 0, but the court also has discretion to give him a new bond to post. So he's still getting his bond revoked, losing his prior bond, but having the ability to bond out. He has 3 kids in which he supports. Their ages are 9, 4, and 2. He delivers for Toshiba, and he's a technician for Toshiba for the last 4 years. So we ask the court to take that into consideration. And if the court is going to revoke his prior bond, to set a new bond instead of 0.
Thank you. State?
Yes, Your Honor. As it pertains to the probable cause challenge, the affidavit makes note of the fact that he has, an officer's eyes or in his knowledge, which is what he relies upon, his actions as it pertains to distancing himself from the passenger seat. He's the only one sitting in the passenger seat the entire time. The gun is found under the passenger seat where he was seated. So that's what the state's position would be as far as probable cause that the officer satisfied it constructively with his knowledge of being there in the seat where it was located and his actions subsequent to it that the officer interpreted. As it pertains to the other bond conditions, that the state is cognizant of counsel's statements, his issues with caring for his children, and state's okay with doing such, if that's what this court wants to do with those.
Well, hold on, the state's okay with doing such setting, revoking and setting?
In setting new bonds, yes, Your Honor.
Okay.
I apologize for not being clear.
No, you were fine, I'm just trying to keep up with you.
Yep.
Okay.
Thank you.
Counsel, do you have a response to, state's response to your argument regarding
I
probable
rest
cause?
on my prior arguments, and he has no objection, so I'd ask that the court take our stipulation into consideration in setting a new bond.
Okay, now you got ahead of me. I was only asking about the PC thing first.
Oh, the PC, as far as my arguments, I mean, he didn't know, but he's right there. It's constructive possession.
Right, so the court finds probable cause. So the court will Court will revoke 1 and 2. I'm leaving count 3 alone, but the court will set subsequent bonds for counts 1 and 2, and the court will set, hold on, no act on 3. And so the court just set, was it 10,000?
Yes.
10,000. So the court will set 10,000 as the bond in count 1 of the prior case.
Okay.
And the court will set 2,000 for count 2 in the prior case. So count 1 is possession of the firearm by a convicted felon, which is consistent with what the court just set for this case. And then count 2 is the carrying the concealed firearm. So to recap, 10,000, 2,000, and leaving it as is for count 3. Any questions or comments, State?
Just to clarify, Your Honor, on this case, the actual case we're here for today, though, it was 10,000 count 1 and ROR count 2?
Correct.
Okay, that's it.
Nothing else?
Nothing.
Nothing further.
Okay, thank you. Thank you, sir. Mr. Smith, thank you. And we're on to, well, I'm going to talk to you, Jones, right?
Yes, Your Honor.
Thank you, Ms. Daly.
You're on your next case for Nathaniel Jones. He is mental health.
Okay, hold on just a second. Let me make sure I'm doing what Madam Clerk wants me to do. You sure? Well, okay, well, I know you're listening, but is there anything else you have for me? Because I'm going to forget everything we say as soon as we leave this case.
No,
Okay, it's your last chance. Anything else for this guy? Mr. Smith? All right, so, okay, what does that mean?
He is not going to be able to come to court due to his mental health status.
Okay, so, I will appoint the public defender. Does the public defender want to proceed without him?
No, Your Honor, if we could ask for just a reset for tomorrow, we'll see if he can come at that time, and if not, then we'll waive tomorrow.
Okay. Okay, we'll reset, but you're in charge of telling that judge that I tried to go forward.
Yes, Your Honor.
It was not me. All right, what about Valencia Desire? We're going to get to the bottom on how to say her name. Hello, ma'am. Right here. I know, it's hard with everybody wearing masks, right? We should have little thought bubbles. How do I say your last name?
I have 2 last names.
What are they?
Fort Desir.
Desire. Kind of got it right. Okay, Ms. Desire, you are here. So I know that we have a prior case, but we're going to deal with this one first. That's 22 MM394. And you are here, I'm trying to lick my finger and I have a mask on. You are here on petty theft. The court finds probable cause, and the court would be inclined to order a $250 bond in the current case. State?
No objection, Your Honor.
Defense?
Your Honor, if I may be heard as to that, she actually has been adjudicated incompetent in another case, so we would be requesting ROR. She was adjudicated incompetent before Judge Allen on April 21st of 2021. She's actually set for a status in that case in March.
Okay.
Due to
All right,
that.
thank you. State?
No objection, Your Honor.
So you can keep going on, but I didn't need to hear anything else, so I hope you don't mind me cutting you off.
No, that's okay, Your Honor.
You're like, yeah, when I'm winning, I'll stop talking, just tell me. All right, so then in that case, the court will order her ROR in the current case. And then as it relates to, I am going to take no actions as it relates to the other cases.
Thank you, Your Honor.
Well, I should ask State?
No objection, Your Honor.
All right. Hold on. Desir. Thank you, Ms. Desir. All right. You're gonna tell me when we're done with this. Thank you. Was that? I think I'd like to know that. You know what I mean? Are you Miss Lisa Lewis?
Yes, I am.
Okay, I'm over here.
Oh, hi.
Hello. So you are here today, ma'am, in case number 2022 MM398, charged with trespass on property after a warning, and the court would be inclined to ROR her after finding probable cause and appointing the public defender. State?
No objection to an ROR, Your Honor.
No objection, Your
Counsel?
Honor. No objection, Your Honor.
Didn't think so, but I figured I'd
Thank
ask
you, Your
anyway.
Honor.
All right. Thank you, Ms. Lewis. Hi there, are you Mr. Briscoe?
Yes, ma'am.
Hello, Mr. Briscoe. Hey, you are here today in case number 2022 MM68. You have been charged with, bear with me, sir, disorderly conduct, and the court finds probable cause. The court is going to appoint that lady as your lawyer, and the court would be inclined to ROR him. State?
The state would have no objection, Your Honor.
No objection from the defense, Your Honor.
Thank you. All right, Mr. Briscoe, you take care of yourself, all right?
God bless you. Yes, ma'am.
Thank you. Uh-oh, can't find my Post-it note. Hi there, are you Miss Nicole McKelly?
Yes, ma'am.
Oh, hello, good to see you, ma'am. So we are here today in case number 2022 MO76, where I find probable cause. I'm going to appoint the public defender to represent you, ma'am. I think I mentioned you've been charged with disorderly conduct. Did I say that? Okay. Apparently I'm redundant. And the court would be inclined to ROR her and take no action in the prior case. State?
No objection, Your Honor.
Defense?
No, Your Honor, thank you.
Thank you. All right, ma'am, you take care of yourself, okay?
Thank you for your time.
Thank you. Thank you for your attention. All right, Camacho Pagan, that's what I'm going with. Okay, we're done. Move ups. I got you. All right, are you Mr. Camacho Pagan?
Yes, ma'am.
Yep, thank you. So here in case number 2022 CF601, you have been charged with aggravated assault, dating violence, battery, dating violence, and possession of ammunition by a convicted felon. The court finds probable cause. The court's going to appoint the public defender to represent you, and the court is inclined to, hold on, let me see. The court is inclined to, oh yeah, keep that mask on.
Sorry.
That's okay. I thank you for catching that, Madam Officer. The court is inclined to order the bond $500 for count 1, $500 for count 2, and $1,000 for count 3, pending hearing from state and defense. State?
So the information received from, I'm not sure if this is from pretrial release or from Orange County Corrections, was that he qualifies as a violent felony offender of special concern, which is subject to no bond based on.
Hold on, Madam Defense, I'm not sure if did you hear what he was saying? I did not, Your Honor. Okay, and I appreciate that you are multitasking like a machine, so I'm just going to ask State to repeat that, because I think you're going to want to hear this.
The only thing is I'm not certain what the probation's from, because it doesn't give me that information on the sheet, but it does indicate that he is a violent felony offender of special concern, meaning he was on felony probation, he picked up this new offense, which therefore makes him no longer entitled to a bond, based on, I'm not sure, I believe it's the aggravated assault in this case that does that.
You can believe what?
I believe it's due to the aggravated assault while he was on felony probation.
State, or no, Defense.
Your Honor, I don't have that before me. He's indicating he's not on probation, and there's not a violation of probation here, so I believe he is entitled to a bond.
Yes, Officer Davis, Your Honor, if I could speak,
Hold on.
he, sorry, he's not on probation. He's not on probation. The charge aggravated assault, generated the violent felony offender of special concern detainer, but it was taken off due to him not being on probation, so he's
Gotcha.
not a BFOSC.
Okay, then the state withdraws that.
Defense, any comment, and/or do you need me to repeat what I was ordering bond-wise?
No, Your Honor, I've got it. I'll just make sure I have it correct. On count 1, it's $500, count 2, $500, count 3, $1,000.
Correct.
Then nothing further, Your Honor.
Okay.
Any conditions, Your Honor?
Oh, thank you. Hold on, you're not going anywhere, Mr. Camacho Pagan. Thank you. You voice from below. Are you no contact with the victim and no returning to the scene. Do you two live together?
No.
Okay, so you don't need to retrieve anything. Okay, so no returning to the scene and no contact with the victim. Talk to her, not me, because when you try and talk to me, that makes them nervous. Thank you. 1,000, I think? Oh, you don't want to actually.
Okay, I'll ask her. Your Honor,
Yes.
so this situation occurred at his sister's house where he lives. Is he allowed
Okay, so, thank you. So I'm going to remove that condition. The condition will just be no contact with the victim.
Yes, Your Honor.
Thank you for that clarification, sir. And no prohibition on the place. All right. All right, are you Willie Lee Jones? Huh? Hold on. She knows that she can't move on to the next one because I'll forget, so I'm sorry if you'll bear with us a minute.
Okay, I see all just sent me an email. I just want to make sure that the defendant you release on pretrial release and want to reset him for tomorrow for the state provide. That was correct, right? That's what we said.
Yeah, well, I'm sure she's nervous. Like, wait, did they really do that? And if so, we'll blame it on Mr. Mizakaba. Hold on, don't anybody say anything. I'm so close. Mikazuki.
Mikazuski.
I was so close. Mr. Mikazeski.
Mikazuski.
So they're still talking, so I can keep doing this. Mikazuski. Hold on. You spell your name wrong.
No, I spelled it that way on my whole
It
life.
should really be Z-O-O. Mikazuski. 'Cause I think it's Z-E-W, right? Yeah, Z-O-O would make it much more easier.
ZEW is the Polish thing.
Yeah, it's Mikazuski.
Yep.
Okay. Well, the good news is I still have this whole stack to go through, and I got your name before the last case.
Excellent.
Hold on, I'm so busy reading your name, I gotta figure out what the heck I'm doing. Okay, so he's out on 2 bonds. You ready?
Yes, Your Honor.
Okay.
Thank you.
Yeah, no worries. So the court will appoint the public defender if I did not already do so. And I'm just going to start over because I'm not sure what I said. Case number 2022 CF 581. Mr. Jones, you have been charged with, hold on, I can answer this, with battery, committing domestic battery by strangulation. I know that there are prior cases he's out on bond for, and we're going to address those in a moment.
Yes, Your Honor.
To keep it straight for me. The court finds probable cause, and the court would be inclined to set a $1,000 bond. State?
The state would have no objection with the conditions of no contact, no return.
Right, do they live together? Yes,
Your Honor.
yeah, so you cannot contact the victim and you cannot return to the place. If you have stuff there, you know, like your daily life, I'm gonna allow you to return with law enforcement once to retrieve your personal belongings. Any objections, defense?
No, Your Honor.
Okay, so as it relates to the prior bonds, it looks like there, Mr. Jones is out for driving while license was revoked as a habitual offender and battery. So as it relates to the first, the court is going to do nothing on that, but the court is going to revoke the bond in the second case and not set anything in the second case as it relates to the battery. That's what the court is inclined to do.
First case number is the CF or the?
Or is that what this is?
Yes, that's the one you,
That's, I did nothing in that one.
no action on that one, okay.
And then the MM8357, I'm revoking the bond and not setting a new one. That's my inclination. Let's hear what the state has to say.
Just wanted to clarify, Your Honor, you were revoking the bond on the battery, right? As well as you're taking no action?
Correct. I didn't hear what you said. The no action was whatever the first thing was.
Yes, the battery is the revocation.
Correct.
No objection from the state.
I don't. Probably going to give you this, but not yet.
And Your Honor, maybe heard as to the revocation for that battery charge.
Sure.
In this case, we would ask to set a new bond in that case, so he would be able to be released. In that case, he's indicated that that is not the same person as this case involving where we're currently at.
I'm not sure that battering a different person means that that's going to go away, so I'm going to, my order's going to stand.
Yes, Your Honor.
You can, sir, you can always, your lawyer can always file something in front of the division judge, but I'm not going to issue a bond today. But that was good. Different victim.
I tried.
I'm trying, doing your job. Hi, are you Miss Soto Pagan? Okay. You're here today, ma'am, in case number 2022 CF573. You've been charged with battery, committing domestic violence by strangulation, count 1, and count 2, battery, domestic violence. I'm going to appoint the public defender to represent you, and I find probable cause. I would be inclined to.
She qualifies for PTR, Your Honor.
Oh, she does? Oh, okay, wait, she does? Oh, thank you so much. Oh, keep your mask on. Keep your mask on. That's all right. Excuse me just a minute. Happy to stop what I'm doing and interrupt all y'all if it's that important. But he needs to make that determination. What do we need to do? Does she need
No, she's
time?
okay, Your Honor.
Are you sure?
Yeah, we'd just like to ask for a pretrial release, and she's
Yeah, yeah.
okay with conditions.
Do they live together?
They did, Your Honor. She's willing to maintain a separate residence.
That wasn't my question. Do they live together?
They did.
Already moved out.
Okay, ma'am, for your own sake, don't talk unless your lawyer says to do so, okay?
Yes,
But-
Your Honor.
Okay, so no contact with the victim, and she moved out of victim moved out of defendant's house, so I don't need to worry about we just no contact with the victim. Any objection, state?
No objection, Your Honor.
Pretrial release it shall be. Thank you, counsel.
Great. All set, thank you.
Just pretrial release, no contact with victim.
Correct.
You're welcome.
Yeah, because victim moved out of defendant's home.
I'm sorry, Your Honor. In a side of caution, can we place a maintain separate residence just in case when pretrial do reach out? Okay.
Yeah. I mean, you can tell me more if you want, but I don't need to hear it.
Okay.
I will do as you say. Mr. Alvarez? Okay. Okay. We're here to, sorry, forgot to sign something. Okay. We're here, case number 2022 MM406, a violation of domestic violence. I will appoint the public defender to represent you, sir. And the court finds probable cause, and the court would be inclined to set bond, hold on, pretrial release. Yes, actually, the courts would be inclined to grant pretrial release pending any argument from state.
No objection, Your Honor.
Defense, sound good to you?
Yes, Your Honor.
Okay, thank you.
Any condition, Judge?
Oh, I forget those conditions. Well,
Any condition of injunction?
yeah, so, but whatever, don't continue not doing what you're not supposed to be doing, although you might have done it. Well, isn't it just a violation of them? Yeah, so no contact,
To comply with all conditions of injunction.
yeah, comply with all prior, sorry, I'm so sorry, I didn't think that I needed to, but you're right, maybe it does bear repeating. How do you say your last name, ma'am? Beebe? Okay, I wasn't sure if it was Beebe or Bebe or, okay, and we have a gentleman here. Okay, so Ms. Beebe, you are here in case number 2022 MM397. I am going to appoint the public defender to represent you. And I see that you have been charged with battery, domestic violence, and we have a witness. Sir, if you'll raise your right hand. Do you swear or affirm to tell the truth in this matter?
I swear.
Do you wish to be heard?
Yes, ma'am.
Hey, the state attorney might have some questions for you.
Sure.
Can you please state your name, please, sir?
Victor Johnson,
All right, Mr. Johnson, how do you know the defendant?
that's my ex-wife.
And do you currently live together?
Yes, sir.
You say ex-wife, how recently? Were you separated maritally?
Well, we're going through a divorce, but we still live together.
Okay. When you said you share the same residence, if she got released from jail, would she come back and live with you still?
Yes,
Is that what you wish to have happen?
yes,
Do you have any fear for your safety if she's released?
none at all.
Nothing further, Your Honor, from the state.
Defense?
Nothing, Your Honor.
The court finds probable cause and will be inclined to grant, we'll be inclined to grant a $500 bond. State?
No objection, Your Honor, with the no hostile contact.
No hostile contact.
No objection to either of those, Your Honor.
Thank you. Thank you, sir. Are you Mr. Eugene Jarrett? I know, it's weird to talk, we need little thought bubbles, it's okay. Sir, we're here on case number 2022 MM401. You have been charged with domestic violence battery. I'm going to appoint the public defender to represent you. I find probable cause, and I would be inclined to set a bond in the amount of $500 with a condition of no contact. Are you two living together?
Yes, ma'am.
And then maintain separate residences. State?
No objection to that, Your Honor.
Defense?
Your Honor, he qualifies for PTR, so we would ask for pretrial release.
This is Eugene Jarrett.
Yes, Your Honor.
I have,
He doesn't? Okay, sorry, it said it on my paper, so that's fine, Your Honor.
okay, thank you.
So 500.
500.
Okay.
maintain, is it maintain means, oh, you know what, excuse me, hold on, Mr. Jarrett, oh, when you're done, go ahead.
No, you're okay.
Do you need to return to the residence to pick up some stuff?
I'm really not sure how I'll go about this. I kind of do, but
Okay, so look, for purposes of me, the answer to that is yes, meaning what I'm going to do is I'll allow you to return one time with law enforcement if you decide you want to. If you choose not to, you don't have to, but it's going to be a lot harder for you to get an order to go back and get stuff than for me to allow you to do it today. So if you choose not to do it, that's your choice, but at least you have the opportunity to do that. Okay?
I would appreciate that.
Sure, no worries, thank you. Madam Defense,
Yes, Your Honor.
I see he doesn't qualify because the form's incomplete. Can I provisionally appoint him?
Yes, Your Honor.
Okay, that's what I thought, but I want to make sure. Hey, are you Mr. Lyons?
Yes.
Okay, Mr. Lyons, you're here in case number 2022 MM35, charged with battery. The court finds probable cause. It appears the paperwork is incomplete about whether I can appoint the public defender to represent you throughout the case, but I can provisionally appoint her to represent you today. I see you qualify for pretrial release, so I'm going to do so under the auspices of no contact with the victim and okay, well, hold on, thank you. Strike most of that, other than the pretrial release. Ma'am, do you wish to be heard?
Yes, please.
Okay, if you'll raise your right hand. Do you swear or affirm to tell the truth in this matter?
Yes.
Okay. State?
Well, ma'am, can you state your name, please?
Rebecca Henderson,
And Ms. Henderson, how do you know the defendant?
he's my boyfriend.
And do you currently live together?
Yes.
And how long have you been dating?
7 years.
And do you wish to have contact with him if he's released from jail?
Yes.
Do you wish for him to be able to return to the residence?
Yes.
And do you have any fear of him doing so?
No.
There was also some information here about ties to his community not being well. Are you confident if he's released, he'd be able to appear in court?
Yes.
Nothing further, Your Honor.
Defense?
Nothing, Your Honor.
So the court will order a pretrial release with no conditions other than actually no firearms.
And no hostile contact, Your Honor?
No hostile contact, thank you. Yes. Thank you, sir. Are you Camille Parks?
Yes, ma'am.
Okay. And this is case number 2022 MM402. You've been charged with battery domestic violence.
Yes, ma'am.
No, I'm just looking to see if we have any witnesses here because I've been neglecting them. I will appoint the public defender to represent you, and I see that you do not qualify for pretrial release, so the court would be inclined to set a bond for $500 with conditions of no contact and no return to, that's right, no. Yes, the court would be inclined to set a bond of $500 with no contact with the victim. Do you two live together, right? You're married?
Yes, ma'am.
Yeah. And no return to the residence. State?
No objection, Your Honor.
Defense?
No objection to the bond, Your Honor, and we would just request a one-time return with law enforcement to get belongings.
I'm sorry, what did you said no objection to the bond?
No objection, Your Honor.
Okay, and one term, yes, absolutely. Assuming state doesn't object?
No objection, Your Honor.
Okay.
So no return one time, enforcement one time.
One time with law enforcement, no contact, 500.
Your Honor, I just have one question.
Sure.
So Ms. Parks is from out of state. She's from Georgia. Is she permitted to go back to Georgia? That's where she's from.
Yeah.
Please.
I mean,
Work.
no, I understand. I mean, we'd love to have you back here in Florida, not let you leave, but absolutely,
I just
go.
wanted to
Yeah.
clarify that she can return there and
Yes.
just needs to come
Yeah.
to any future court dates.
Yes, yes. Just because you live in Georgia can't ignore here in Florida.
Can we do like a virtual or something?
I'm not in charge of that. That's above my pay grade.
Oh, okay, okay. I was just asking.
No, I understand. I just can't answer it. I don't know.
Okay, okay.
Maybe. Thank you.
I'll have to put that on, order. Is she gonna turn over?
I don't think so. Well, let me ask defense or state. There's no prohibition about her going, i.e. that she has to stay in the state, right?
Correct.
So we don't need to indicate she can go because there's nothing that says she can't go. Right? I don't want to get in trouble.
As long as she appears for court, that's all that I think
Yeah.
we have to worry
It's
about.
not on probation or PTR or anything like that.
Right.
So I didn't think so, but just for
No,
clarification.
no, I appreciate everyone's like, oh, let's make sure we get this right. Okay. Ms. Dana Pratt?
That's me.
Okay, we're here on case number 2022 MM404. You've been charged with battery domestic violence. The court finds probable cause. The court also sees that there is a witness. Sir, are you looking to testify?
Yes, ma'am.
Okay, if you'll raise your right hand. Do you swear or affirm to tell the truth in this matter?
Yes, ma'am.
Right, the state's going to have some questions for you, but before he does, Ms. Pratt does not qualify for a public defender, but the court will provisionally appoint the public defender for purposes of today.
Yes, Your Honor.
State, questions for the gentleman?
Sure. Good afternoon, sir. Can you state your name, please?
Yes, Kejin Dorset.
Mr. Dorset, how do you know the defendant?
She's my girlfriend.
And how long have you been dating?
A year.
And do you currently live together?
No, sir.
I'm sorry, was that yesterday?
No, no, sir.
Okay. So if she's released from jail, would you want to be able to have contact with her, or are you in fear of having contact with her?
Contact is okay.
Contact is okay. And you said don't live together, right?
Correct.
Nothing further, Your Honor.
Nothing from the defense, Your Honor.
Thank you, sir, for your testimony. So the court is inclined to issue a $500 bond. Wait, hold on, I don't think.
She qualifies, Your
She
Honor.
qualifies. She qualifies for pretrial release with only non-hostile contact as a condition and no firearms. Well, so I guess that's not only, so there would be two. State?
No objection, Your Honor.
No objection, Your Honor.
Okay, thank you. Thank you, ma'am.
Thank you.
Pretrial release, no hostile, no firearms. All right, are you Donna Wilson?
Yes, ma'am.
Okay, we're here today on case number 2022 MM390. You've been charged with battery, domestic violence. The court will appoint the public defender to represent you. The court finds probable cause, and the court is inclined to issue or order a $500 bond with no contact with the victim. Are you staying, you live with the victim?
She's from Canada, and she's recently come and visit me.
She's staying with you. So how did we do that before? What was the?
Just maintain separate.
Maintain separate residences.
Yes, ma'am.
Okay. State objections or comments?
No objection, Your Honor.
Defense?
The defense.
Okay.
$500.
$500.
Maintain separation.
Yes. Nope, nope, nope. Okay, this guy, he's gonna revoke. Oh, okay, so we will reset that?
Yeah, within 24 hours from his release.
Well, we will reset that within 24 hours of his release. I hope he's okay. Oh, there's more. Listen, it is not a good day to be a Lorenzo. That will also be reset to 24 hours within his release. What about Christopher Duvall? Is he okay? Oh, apparently he's doing quite well. Okay. Donald Gresham.
He's coming,
You
Your
got something for him? Okay. I'm sorry?
He's coming.
Okay. Are you Donald Gresham?
Yes, ma'am.
All right, Mr. Gresham, we're here on case number 2022 CF583. And the court is going to appoint the public defender to represent you. Court finds probable cause, and the court is inclined to issue, or excuse me, not issue, order a $250 bond. State?
Yes, Your Honor. As long as, actually, no, I'm sorry, there's a separate failure to appeal that already has a bond.
Oh, wait a minute,
amount.
hold on. Donald Gresham.
I'm looking at the wrong one, I apologize.
Okay,
I get the wrong
wait,
affidavit.
he does? Oh, yeah, okay,
It's the
hold
wrong
on,
case.
sorry. Thank you. Let me be a little more specific. Count 1, criminal mischief, and count 2, petty theft, and you know what, I didn't, hold on a second, sir. There was the, I wanted to, Valencia Desir, I wanted, does anyone have easy access to what her bond was? DESIR.
Find it.
ESIR. That was ROR.
Yeah, you are.
Yes, she was ROR.
She was the one, she was part of the top of the list. Right, okay. Yeah, yeah, I think that was right. All right, so as it relates to count 1, criminal mischief, the court will ROR, and as it relates to count 2, the court will set a bond of $500. Pending, anything from you, State?
Yes, Your Honor. The state would also seek no return to the Walmart at 3101 West Princeton Street.
That seems reasonable.
No objection. Your Honor.
Okay, that's what we'll do. For 1. Yes. Wait, what did I say number 2 was then? You know, actually, hold on. I'm so sorry. Count 2, we're going to do 250, not 500. Yeah. Thank you, sir. Thank you, you as well. Is this Roderick Hauser? Oh, hello. So we're here on case number 2022 CF590. The court's going to appoint the public defender to represent you. Sir, you have been charged with, you have been charged with fleeing, attempting to elude a law enforcement officer with sirens and lights on, and possession of cannabis with intent to sell or deliver. State, is count 1 fleeing, attempting to elude a law enforcement officer with sirens and lights on, that's a PBL?
No, Your Honor.
No, Your Honor.
It's not?
No.
Thank you. Also, Ms. Defense, for answering that question. Okay, well, the court is going to set the bond on count 1 at $2,000 and count 2 at $500 with the stipulation of no drugs a condition, stipulation, assuming that the state objections?
No objection. I just want to clarify, you said 2,500?
Correct.
Thank you.
Thank you. Wait, is there something? former, is there? No.
And if I may, Your Honor, not on this case, but I went out of order. What did you end up doing with Duval? I was trying to get my paperwork in order. and-
With who?
Mr. Duval, or did we not?
Is he named Lorenzo?
No, Christopher. He was the one after
I
that.
think he bonded out.
Okay,
Yeah,
thank
so bad day to be a Lorenzo, good day to be a Christopher.
you. Thank you.
Yeah, you're welcome. No worries, there was a lot happening.
Wow. I think you bonded, right?
You bonded.
Right, thanks.
Sure. Are you Roderick Hauser?
No,
That was him, okay, thank you. So that means you must be McFerrin
Yes, ma'am.
Mason.
Ma'am.
Okay. All right, sir. Let's see, so you hear case number 2022 CF 595. You do not qualify for me to appoint the public defender, but I'm going to do so provisionally for her to represent you today. You have been charged with, let's see, there's nothing for. You've been charged with 4 counts: 1, possession of a firearm / ammo by convicted felon; 2, possession of cocaine with a weapon; 3, possession of cannabis less than 20 grams; 4, possession of a firearm / ammo by convicted felon. I have a question about that in a moment. And count 5, grand theft 3rd degree with a firearm. Is count 4 the same as count 1?
The exact same statute.
yes, Your Honor.
So there's only 4 counts then?
And I believe he's charged 2 different counts or
Yeah,
2 times with it.
Count, the officer's charging for each bullet.
Oh, okay.
Sorry for each, allegedly for each.
Alleged thingy, alleged, okay. All right, thank you, Madam Clerk, because I wasn't sure as far as that being redundant. And I believe I said I found, of court finds probable cause. The court is inclined to issue the bond, order the bond in the amount of $4,000 for count 1, $5,000 for count 2, ROR count 3, 4,000 for count 4, and 1,000 for count 1. State?
Just, you said 1,000, it's count 5, right, for the,
Oh, yes, I'm so sorry. I read 1,000 and then said count 1. Thank you so much for,
sure thing.
sorry, I'm not trying to make it more confusing.
No worries, Your Honor. State would have no objection to those bond amounts.
Defense?
No objection, Your Honor.
Okay. And that will be the case. Oh, and the condition will be no firearms and no drugs.
Let me make sure. 4,000 for count 1.
Hold on. Oh, you guys are good. She's clear. She's making sure.
You're reducing count 2 to 5,000.
Mhm.
They all are reduced. And stay. Okay. I got it.
Well, I don't know what stay and, yes, stay and stay. Yes. Okay. Did I remember, oh, can you toss my Post-it too, please? Thank you. It's somewhere in there, I think. Yeah. Yes.
Mr. Meek Court,
Bonded? Okay. Oh, that's probably why I don't have the sheet. Okay, so Mr. McCourt, no? So that means you must be Mr. Rivera.
Yes, ma'am.
Hello. Okay, Mr. Rivera, you do not qualify for me to appoint the public defender, but I'm going to appoint her provisionally for today. You're here on case number 2022 CF 584. And, you thought you guys would get by me, 2022 CF 585. So there are 2 cases, and there's prior bond. So we're going to deal with the prior bond issues after we deal with the 2 cases and the various counts. So first case in 585, you are charged with grand theft 3rd degree for greater than $750, but less than $5,000. Bear with me.
Yes, ma'am.
The court would set that, be inclined to set that bond at 2,500. Did I just do the right, oh, you know what, excuse me, guys, I'm so sorry, hold on. That was actually case number 585, the second case. So the first case had 2 counts, but since I already got into the second case, so case 585, grand theft, 3rd degree, greater than 750, less than 5,000, the court would be inclined to set that bond at 2,500. And in case 1, the first case, which is case number 584, you've been charged, sir, with grand theft, 3rd degree, less than 750, greater than 5,000, and resisting officer without violence. The court would be inclined to set that bond at 2,500 for count 1 and 100 for count 2. We'll deal with the other, again, the bonds separately. For the prior existing bonds, let me get this squared away. State, any objections to those?
No, Your Honor.
Defense? I'm happy to repeat anything because I gobbled that and I apologize.
That's okay, Your Honor, I got it.
You're like, no, I got this. Okay, so no object, so we're good with that? Okay. Then, so as I understand it, there are 2 prior cases for which you have bonded out, Mr. Rivera, 2021 CF 13546, which is grand theft, 3rd degree. The court's going to revoke that bond and not set another one. And the Osceola case is 2021 CF 3268. The court is going to revoke that bond and not set another one at this time. That's the inclination. State?
No objection, Your Honor.
No objection. I can just see. Your Honor, just as to the other 2 charges, the 13546 and 3268, could we just ensure that he was, oh, I guess he's not entitled to a public defender. Never mind. I just realized he doesn't qualify, so he wouldn't qualify in those other 2 cases.
Oh, right. Well, should I provisionally appoint him, though, in those other 2 cases for purposes of now?
Case is 21 CF 13547, he do qualify. He do have a public defender for the other case.
Okay. I just wanted to ensure he had a public defender just for the purposes of bond.
So, okay, well, the court will thank you. The court will provisionally appoint the public defender in the 2, the PD's either appointed or will be provisionally appointed in those 2 cases where the court is revoking the bonds.
You don't qualify.
Okay, so what, like,
You
do
get
I
a-
do, how long I sit in?
I don't know.
Just one moment, if you all would. I'm texting with the officer who had filed a warrant for my review, and I'm confirming that he can wait until I'm done here, or if I need to stop. So I apologize. Just one moment. Can you review that affidavit, or can it wait? Okay. So again, I apologize for that. And that was Mr. Rivera previously, correct?
Yes, Your Honor.
Okay, Mr. Rosario?
Yes, ma'am, Your
Okay.
Honor.
We are here today in case number 2020 CF 14962, where you, is that the only one? Where there's been the failure, well, where you've been charged twice for failure to appear, and the original offenses were possession of cocaine and possession of drug paraphernalia. You do not qualify for pretrial release. I will appoint the public defender to represent you.
May I say something on my behalf, Your Honor? I am homeless, and I have no place that I receive any mail to be notified concerning my court cases. And the only place that I was able to receive that is on Good Samaritan on
Mm-hmm.
9837 East Colonial. And I also reside in the property. And I was trying to get in contact with the public defender office to see when it was going to be my court date, and it was never notified.
Okay, just a moment. State, I want to hear, I'm going to want to hear your response to how we should address this. Is there anything else you need to tell me, sir, or is that it?
No.
Okay, thank you. State?
Yeah, the state would just have concerns about getting his appearance in court. If he's unable to receive mail, the state would want to inquire as if how he's able to contact the public defender to actually ensure his appearance so that this doesn't happen again. Otherwise, the state would request that you maintain the bond amounts on the fee to appear.
Defense, is there anything else is there anything you want to add on his behalf, or?
Yes, Your Honor,
Okay.
I just spoke with him, so he is homeless, he doesn't have a phone, he knows where the public defender's office is located. We can try to reach out with social services to get bus passes, and if he comes to the office, we could give him the court dates at that time. I understand it might be difficult for him to do that, but he's willing to do so. So if Your Honor would consider all of that when making a determination as to how he could be released.
Sir, I'm very sympathetic to what you're telling me, but it's very hard for me when you've already demonstrated that you're not going to come to a hearing. It's hard for me to be sympathetic your second time.
But may I say something, Your Honor, if you don't mind? Several times, I think I was in the past release on RN. I never have no problem coming to court. I'm 55 years old. I'm pretty aware of what's happening, but I never had a problem coming to court. It's just like I said, I had that problem.
So here's what I'm going to do. I'm going to set the bonds for those two counts at $500 each.
And is it possible to see if TRC or whatever?
PTR, you don't qualify.
Or not even R?
No.
Okay.
So you got bonds.
Okay, well, so the judge had previously set it at the 2,500 and the 1,000?
The bond?
Yeah,
Yes.
you have bonds, they were reduced,
Okay.
so if you can
I
afford.
have $100 each.
Yep, but it.
Yes,
Okay, thank you. Thank you, Your Honor.
you're welcome. Wait, this is a different guy. Hello, sir, are you Thomas Brett?
Yes, ma'am.
Okay, so we are here in case number 2022 CF 592. You have been charged with possession of cocaine. I am appointing the public defender to represent you. The court finds probable cause, and the court is inclined to set a bond at $250. State?
No objection to that, Your Honor.
Defense?
No objection, Your Honor.
Thank you. Thank you, sir. Correct. Okay, so I have a little Post-it note on my next one that says I might be screwing up the order of the next few documents because I kind of did stuff with them, so maybe you guys can tell me who's next.
Wanon, Wahnon.
Oh, yeah, I definitely screwed it up. Carlos Wanon, thank you. Mr. Wanon,
Yes, ma'am.
you are here in case number 2022 CF 604, charged, hold on, charged with leaving the scene of a crash with injuries. And the court is inclined to set the bond at $1,000. State?
No objection to that, Your Honor.
Defense?
No objection, Your Honor.
Okay. I'm going to do that.
Let's answer
Nope.
this one. Torres Martinez.
Yes. Is he next?
I can ask.
Yeah, he won't be able to bond out due to he has a hold for the VFOSC because he's on state probation.
Wait, are you talking to me?
I was talking to the defense attorney.
Okay, good.
So he's a hold, so.
He has the 5-day hold.
I'll ask about the Torres.
So I paid yesterday.
Yeah, the reason why they took that bond back off, because you're a violent felony offender of special concern, so you couldn't bond out.
All right, so I have to wait 5 days.
To see if the probation officer wanna,
So did Torres bond out?
He's not on ours. Yeah, he's not on our list, so he must have, yeah.
You want me to say that? Do I, okay. So inmate, 2201230. Can somebody see if he bonded out? I need a little mirror. Can you see if,
can you repeat the number, Your Honor?
yes, 2201230. Josias Torres Martinez.
He bonded.
Okay. And Deshaun Williams?
Yes, ma'am.
All right. So if that other gentleman bonded out, I might not have screwed up the order. All right, let's go with that. All right, so Mr. Williams, you are here on case number 2022 CF 574 with 3 charges: attempted robbery, tampering with a witness to hinder communications to law enforcement officer, and criminal mischief for greater than 200 and less than 1,000. You do not qualify for pretrial release. I'm going to appoint the public defender to represent you, and I am inclined to set bond at $3,500 for the attempted robbery, $1,000 for the tampering with the witness, and $500 for the criminal mischief. State? That was very loud, sorry.
No objection, Your Honor.
Okay. Defense? Taking a moment.
Your Honor, if I may be heard as to bonds.
Just one moment, let me do one. Certainly.
Yes, Your Honor, he's indicated he would not be able to afford to bond out, which would be akin to holding him without bond. So we'd ask for a reduction as to count 1 and count 2. If you'd be inclined as to count 1, making it $1,000. And I guess staying at count 2 at 1,000 and count 3 at 500, you should be able
State.
to bond.
No objection.
So done.
Thank you, Your Honor.
Welcome. Don't thank me. Thank your lawyer.
Thank you, Your Honor.
You're welcome.
Count, what we did, we changed the bond to 1,000. Okay.
So we only really changed the first one.
Just the first one, yes, sorry.
Okay, can, Mr. and Ms. Correction Officers, can you sit tight on our next person for a minute? I did hear back, and they really need me, apparently, at the scene of the homicide. So if you guys don't mind, actually, this might be a good time, maybe, I'm off the record.
Assuming you bonded?
2200123.
Bonded.
Goodbye. Oh, wow, all right, oh, jeez, okay.
Castillo Herrera is behavior, right?
What does that mean?
So he won't be able to come today. We could reset him for tomorrow and see if his behavior is better.
Is that what you want to do?
Yes, Your Honor.
Okay, so Castillo Herrero, we will reset for tomorrow.
I didn't hear, Your Honor. How come he's being reset?
What?
Why was he being reset?
Behavior.
Behavior.
Okay, thank you.
Elizabeth, Hunt, Wilder,
Hunfelweiler.
she found it.
Hunfelweiler.
Bonded, okay.
Well, that's probably for the best, then she doesn't have to hear us mangle her name.
And we have Logan.
Mr. Lohman.
Good morning, good afternoon, how you doing?
You know, and I've been saying good morning all day too, so I appreciate you helping me be wrong. All right, so Mr. Lohman, you're here in case number 2022 MM 400. I'm going to appoint the the public defender to represent you. You have been charged with fraud, impersonation with a knowing intent, unlawful possession, 4 or fewer identifications. The court finds probable cause, and the court would be inclined to set the bond at $500. State?
No objection, Your Honor.
Hoffenwalder.
Oh, I think I can.
Okay, good. Okay, well, you can throw it away. I just can't. Hoffenweiler.
Your Honor,
Yes.
Mr. Lohman indicated he wouldn't be able to afford to bond out. Are there any non-monetary conditions that, of release that he could have?
I feel like that's more of a question for you or pretrial person, although, well, no, pretrial, so pretrial doesn't qualify for pretrial.
Yes, Your Honor, so we'd be asking for ROR because he cannot afford to bond out.
Well, but you also said, are there any other conditions? So maybe state, you want to bond out, jump in on this?
The state would object to ROR based on the information provided to us when he was screened by pretrial services, that he gave conflicting information as to his address, and his community ties were unable to be verified, and there's no employment, so we're concerned about his ability to appear in court in the future.
Defense?
Your Honor, he's indicating he has an address, and that it's on his identification,
Been staying up for the last 7, 8 years.
and that he's lived there for 7 to 8 years.
State?
The state would still request there to be some sort of condition to ensure his appearance in court.
What would that be? I mean, and is there anything you can think of then other than
A
financial?
monetary bond.
I'm sorry?
I said aside from a monetary bond,
Yeah.
not in this kind of case. Because he doesn't qualify for pretrial release because of the issues I stated.
What about if I reduced it to 250?
He doesn't have any money, Your Honor.
Judge and he just.
Do you have a phone number?
It's still $100 as a minimum, yeah.
Your Honor, he does have a phone number, and because we were appointed, I mean, he can keep in contact with his attorney. I mean, it's his attorney's job to make sure to contact and that he comes to his court dates. So we would be asking for ROR because he has an address and a phone number that he's indicating.
So, Mr. Lohman, you realize that if you don't keep in contact, it's not her job to keep in contact with you. And I can reduce it to ROR, but if you don't attend, then they'll issue an arrest warrant, and the subsequent judge not only will not allow you out on ROR, but 250 will likely have another 0 or greater behind it. So overstates a well-argued objection, the court will ROR.
Thank you, Your Honor.
Listen, look at my face, don't,
I'm gonna take,
And he's got the phone number to the public defender's office, Your Honor.
oh, okay, so, hold on a second, we got more information. Breaking news, what?
I'm gonna set it for an arraignment, February 17th at 1 o'clock,
what date that was?
downtown in courtroom 4C.
February 17th?
Yes.
Yep, at 1 p.m. downtown in courtroom 4C.
1 p.m.
That's the next arraignment date.
Let's look at that, February 17th, that is a Thursday.
Yes, ma'am.
There you go.
It's gonna be on your order here.
I wrote it down right here, I got it.
Okay, you're welcome. Don't thank me, thank your lawyer. right, Therese Marshall coming up. So, it's not appropriate. All right, are you Mr. Therese Marshall?
Yes, ma'am.
I'm sorry? Yes.
No.
You were very tall. Sorry, we're going to adjust the microphone and my ears are bad. All right, so sir, you're here, case number 2022 MM393. You've been charged with trespass on a property after a warning. The court will appoint the public defender. The court is inclined to set a $500 bond. State,
No objection, Your Honor.
counsel?
No objection, Your Honor.
Can I ask a question?
Well, yeah, you want to ask her, not me.
Your Honor, at this time, we'd actually ask for ROR for Mr. Marshall. He indicated he is homeless. He can come to the public defender's office to get his future court dates, and he would comply with that and return to any future court dates.
All right. State,
It would be the same objection to the prior case. He also has a prior failure to appear, albeit 3 years ago, but he has failed to appear once before. I don't know which county that was in according to this report.
so what I'm going to do is I will do the ROR. Mr. Marshall, you have to understand that, one, you're going to leave here with your next court date, so you can't say, oh, I didn't know what it was. If you don't appear and you get arrested, the next judge will not do this, and they will set it likely higher than $500. So, Madam Clerk, if you would tell him what the date is.
February the 17th at 1 p.m., courtroom 4C.
Okay, thank
Downtown.
I read it for you, okay? Your Honor, for Mr. Wilson, we've actually worked out a plea. I just wanted to bring it to your attention. I have the plea form filled out.
Do you want me to, does that mean you want me to take it? Is
Yes,
that one of the, is this one of the ones where I can do that?
Yes, Your Honor, it's a misdemeanor pleable, so he is allowed to plea at IAs. The state and I spoke before court.
Let me find in my binder what I do in this case. Is this Mr. Wilson?
Are you Mr. Wilson?
Yes, ma'am.
I can't hear you.
Yes, ma'am, Your Honor.
Thank you. All right. So, Mr. Wilson, you are here in case number 2022 MM392. You've been charged with trespass on property after warning. I will appoint the public defender to represent you. I am informed by, oh, thank you so much. I am informed by your lawyer that you have worked out a plea deal. Is that correct?
Yes, ma'am, Your Honor.
Okay, so, oh, wait, I need that back. Are you Mr. DeMarco Jamal Wilson?
Yes, ma'am, Your Honor.
Is your date of birth April 1st, 1992?
Yes, ma'am, Your Honor.
Okay. You were charged with, and I said, what did I say? Hold on. Trespass on property after warning. The maximum sentence for that is what, counsel?
1 year, Your Honor.
1 year in jail.
Yes, Your Honor.
Your plea offer is, what is the plea offer?
It's an adjudication of guilt, court costs, 10 days in the Orange County Jail with credit for any time he has, and no return to the scene.
Oh, that's probably what that is.
Yes, Your Honor.
Okay, thank you. I would never have gotten into that. So, you do not have to accept that, sir. Do you want to take a moment to talk to your lawyer?
Yes, ma'am.
Do we know what Oh, nothing to apologize for.
If you would be inclined, Your Honor, we just spoke with the state, and it would actually be 7 days of Orange County Jail with any credit. And he is willing to accept that.
Do we need to change that on the top of here?
Yeah, if you could just scratch out and put 7. Thank you, Your Honor.
Do you want to go back and ask for?
We just
Fine,
confirmed.
Your Honor.
No, I was kidding. You want to go back and ask for 5 because you got.
Oh.
Okay. So do you have any other questions for your lawyer, sir?
No, ma'am, Your Honor.
Do you wish to accept the plea offer?
Yes, ma'am, Your Honor.
So you will be obligated to pay $273 for the court costs. You will have 1 year to pay that. Do you understand that?
Yes, ma'am, Your Honor.
Can you pay that within a year?
Yes, ma'am, Your Honor.
Did you read and understand the waiver of rights plea form?
Yes, ma'am, Your Honor.
You've signed it. Do you have any questions about this document?
No, ma'am, Your Honor.
Okay. Have you consumed any, I'm not sure when you got arrested, so this might be a dumb question. Have you consumed any alcohol, drugs, or medication in the last 24 hours?
No, ma'am, Your Honor.
You are a U.S. citizen, correct?
Yes, ma'am, Your Honor.
So to the allegation that on January 16th, 2022, that you trespassed on the property after warning, do you plead guilty, not guilty, or no contest?
No contest, Your Honor.
Are you entering into this plea that it's in your best interest while maintaining your innocence, or because you believe you're guilty? Boy, what a question is that? I don't like that.
Yes, Your Honor.
Yeah, we'll just go.
It's in his best interest. Your
Yeah, I'm like, this is, just scratch through that on my colloquy. All right, so I will accept this plea. I find the defendant cognizant and understanding what it is that he has agreed to. I find that it is in his best interest. I find that there's a voluntary waiver of rights, and that I will impose the sentence previously indicated. Sir, you have 30 days to appeal the judgment and sentence. You have to file a written notice of appeal with the clerk, and counsel can be appointed to represent you on that appeal if you want to. Any other questions for me?
No, ma'am, Your Honor.
Counsel?
No, Your Honor.
Counsel?
Nothing from the state.
Whew. So today's the, what do we say, the 17th of January, 2020. Let's just smear that. Okay. All right, now is he gonna, okay, thank you. Thank you. Okay. That was Mr. Wilson. Are you Octavius Ambrose? Yes, ma'am. All right, sir. Hold on, we've run into the realm where I don't have paper clips, so I gotta get everything. Okay, so we're here today, sir, on a Osceola County case, no case number, but inmate number 22001188. You've been charged with burglary, occupied dwelling unarmed, larceny, petty theft, first degree, 100 more, but less than $750. This is an over-the-line arrest. The court finds probable cause. The court will appoint the public defender, and the court would be inclined to set bond in count 1, the burglary, for $5,000, and count 2, the larceny, and $500. State?
No objection, Your Honor.
Defense?
No objection, Your Honor.
Okay, that's actually you too. All right. That was right with the over the line. Okay. All right. Hi there, are you Quentin Jackson?
Yes, ma'am.
All right, sir, you are here today. You were charged with burglary, occupied dwelling unarmed, and larceny petty theft, first degree, $100, more than $100, but less than $750. This was an over-the-line arrest associated with an Osceola County case. The court finds probable cause. The court will appoint the public defender to represent you, and the court would be inclined to set the bond at $5,000 for count 1 burglary and $500 for count 2 larceny petty theft. Counsel for the state?
Your Honor, the state would have no objection to that, but would inquire as to if he's going to remain being held under his violation of probation for the Apple County arrest, for them to come get him.
What?
He's being held on a felony probation from Indian River County.
Oh,
Yes. So I want to ensure that even if we give him a bond in this case, that will hold for them to come get him.
is that a question for you?
Yeah, I couldn't understand the last thing you said, but no, he won't be released. He won't
Okay.
be able to bond out, even if he does get a bond.
Okay. Thank you.
And is that, just for my own edification, is that,
Let you know that, let him know if he postponed, he can get no, he's not getting out because he got a.
right, so sir, and how long, is that where that 5-day thing comes into play, or is this?
Yes, Your Honor.
So, sir, because you're, what was that again, state? How did you say that?
He's on felony probation out of Indian River County.
Since you're on felony probation out of Indian River County, if you post the bond, you will still not be allowed out because of that Indian River case. What I just ordered relates to charges here, or rather the Osceola, not related to the Indian River case. I think I did appoint the PD. I did.
Yes, you did.
Thank you for checking.
What was the amounts again, Your Honor?
5,000 for count 1, 500 for count 2.
Thank you.
Thank you. Are you Ms. Carla Smith? Hello, ma'am. We're here today for an out-of-county warrant for Polk County, perhaps a pretrial release for possession of meth, and then count 2, possession of probably paraphernalia. And I will provisionally appoint the public defender here, and the court, well, this is an out-of-county warrant. I don't think I can set a bond because
Have any of that. I was in someone else's home. No, that was my property.
Ma'am, I'm going to ask you to stop talking because that's not appropriate for today, and I don't want you to incriminate yourself in any fashion. Instead, I can't issue a bond because it's the out-of-county warrant. Thank you. Right? They'll come get you within 72 hours.
Polk County?
Oh, yeah.
Yeah, Polk County has to come get you.
Right, are you, what's your name, sir?
Jackie Wallace.
Jackie Wallace. All right, Mr. Wallace. You are here today on charges for 2 counts, 1 burglary, occupied dwelling unarmed, and 2 larceny petty theft, first degree, more than $100, but less than $750. I will provisionally appoint the public defender here. This is an over-the-line arrest, and it looks like the court is inclined to order a $500 bond for count 1 and a $5,000 bond for count 1, $500 bond for count 2, but
No, they just.
okay, so that's what the court would be inclined to do. State?
Yeah, the state would request that he be held similar to the prior cases for Osceola County to come get him. He has 8 pending cases with warrants from Osceola County.
Isn't that, though,
He's still entitled to a bond on these cases. If he
Right.
finds out, he will still need to go to Osceola County if those bonds have been revoked or anything like that.
Can you repeat that part,
Yes, Your Honor.
Ms. Defense? Ms. Defense?
Yes, Your Honor. If he has other cases out of county, he is entitled to a bond in these cases if he has any holds or anything else holding him up. If they've revoked the bonds in those cases, he will be transported over out of county.
So am I understanding correctly then for Mr. Wallace's sake, if he bonds out, it's like the Indian River case where if he posts the bond, he might still not be released because of those other?
If there are any other cases holding him out of county, yes, then he would be transported once he bonds out, or they'll come and get him at a certain period of time. If nothing else is holding him, he could bond out and be released today.
State?
I'm not sure what's holding him otherwise.
No objection, Your Honor. I was just at concern because he has FTAs as well, but that will, as long as that works that way, then we have no issue with it.
Yeah. Okay.
Just want to make sure.
Thank you.
Thank you, Your Honor. So we got bonds. You can-
You have a Carrillo Greenberg next? She refused.
So
It's within the court's discretion, Your Honor. She refused.
what's
so,
your preference?
If you want to provisionally appoint, you can, or you could just find that because she refused, she waived. So that's within your discretion, Your Honor.
Do you have a preference?
No, Your Honor, we would ask for a reset, but it's up
I'm
to the
happy to
court.
reset if that's your preference.
Yes, Your Honor.
And counsel, when somebody, a judge or anyone asks you your preference, give them your preference.
Yes, Your Honor. We would ask for a
If I wanted to tell you how it's going to be, I can do that. Don't tap dance.
Yes, Your Honor.
We'll reset that. Even though, let the record reflect, it took her 3 times to admit that's what she wanted. Trust me, I can tell you what I want. I think we're Timothy Frazier, maybe? Hi there, sir. Are you Timothy Frazier?
Yes, ma'am.
Okay, we're here today. You have been in case number 2022 MO75. You have been arrested for disorderly conduct. I'm going to appoint the state attorney to represent you, and I'm inclined. Nope. It's the second time I tried to appoint the state attorney. You don't want that. Well, he's a good lawyer, but I don't know that you want him for your lawyer. So I'm going to appoint the public defender, that obviously very capable counsel next to you, to be your lawyer. Thank you all. So you've been charged with disorderly conduct.
Continue, Your Honor.
Oh, yeah, no, thank you. The court finds probable cause. Anything you want to tell me, defense?
I was just discussing terms of bond, Your Honor. You would like to bond out, so if you would be.
Okay. The court would be inclined to set a $250 bond, state?
No objection, Your Honor.
Is that good?
Is that?
Objection.
Okay, thank you. Thank you, sir. Did I appoint the public defender? Yes, I did. No, I appointed you, Mr. Mikazuski.
Yes, Your Honor.
Get over there and represent him. It's bizarre. It's like Freaky Friday. You guys are switching jobs. Hi there. What's your name?
Craig Nelson.
Craig Nelson. Mr. Nelson, you are here today on case number 2022 MO77, and you are, bear with me, you have been charged with alcoholic beverage open container. The court will appoint the public defender to represent you, and the court finds probable cause and is inclined to set a bond in the amount of $100. State?
No objection, Your Honor.
Your Honor, if I may, he can't afford to bond out at this time. I would just want to ask the state if there was a way to offer any kind of resolution in this case if you wanted to resolve it today and get released.
Court fees are $223, if that means anything to anyone, or if any, that's going to matter.
Then the state would offer adjudication, time served, to court costs.
Is that what you want? Credit time served to get out today?
Oh,
He's willing to do that, Your Honor. I'm just going to fill out this
Sure.
plea form with him.
well, that'll teach me to learn how to say Mr. Mikazuki's name right. He's. He put it on our record. Yeah, you like how I claim credit for that offer? Because I got your name right.
Okay, so no,
I don't know what you're saying. I'm too busy being hot. What? You talking to me? Me? What? Yes. That was good. Sometimes I don't remember.
Yeah, you got to wait. She's going to ask you some questions.
Why, thank you, good sir. I'm usually, do you want my sweater? You put it on your lap. It'll help. Okay, okay, I'm just saying, no complaining then. Wait, can I have this paperwork back, please? Okay, I'm gonna try my new improved plea form. Right, are you Mr. Craig Nelson?
Yes, ma'am.
And what is your date of birth? Oh, no, I got this. Is your date of birth 7/22/1969?
That's correct.
Okay. And the plea offer, you don't have to accept it. You know that, sir.
Yes, ma'am.
Okay. Do you have any other questions, though, that you want to ask your lawyer before we go any further?
No, ma'am.
Okay. So your court costs are going to be $220. I think that's what I said, right? $223. And you will have 1 year to pay those. Do you understand that, sir?
Yes, ma'am.
Okay. Did you read and understand the waiver of rights plea form before you signed it?
Yes, ma'am.
Do you have any questions about the document?
No, ma'am.
Have you consumed any alcohol, drugs, or medication in the last 24 hours?
No, ma'am.
Do you understand what is happening today?
Yes, ma'am.
Are you a U.S. citizen?
Yes.
To the allegations that on January 16th, 2022, you committed the offense of having an alcoholic beverage open container, do you plead guilty, no contest, or not guilty?
No contest.
So I will accept your plea, finding that you understand what you are signing. You have no further questions. You appear competent and intelligent and know what's going on. I will find that there's been a voluntary waiver of rights and that I will impose the sentence previously agreed to, which is credit for time served and court costs. You can't get out of those. You have 30 days to appeal this judgment and sentence. You would file a written notice of appeal with the clerk, and counsel can be appointed to represent you on the appeal if you qualify. Any questions for me?
No, ma'am.
Okay, well, thank you, sir. You're taken care of. I was a little better than the last one. Didn't ask that weird
Same
question.
thing over and over.
Are you entering it? It's in your best interest, or because you believe you're guilty? Like, I can't even ask that question. Okay. Let's see. You, Mr. Newhart? Nahart. Oh, I'm so sorry. Nahart. Oh, so sorry. Just a moment. I've got to sign a form. 17th. It's probably not a plea until I sign it, right? Oh, are you good?
Yes, yes, Your Honor, thank you.
So we're here today, Mr. Nyhart, in case number 2022 MO78. You have been charged with disorderly conduct. The court finds probable cause. The court will appoint the public defender to represent you. I understand that you are out ROR for charges of possession of cocaine and possession of drug paraphernalia. The court is not going to do anything about that, not revoking that prior ROR, and the court is inclined to set a bond for $250. State?
No objection, Your Honor.
Just a moment.
Sure.
Your Honor, he can't afford to bond out at any amount. If the state has an offer, he would be inclined to resolve the case today.
The state would be willing to do a time served court cost offer on this case as well, adjudication, guilt.
You want to do credit time, sir?
You said adjudication of guilt?
Yes, Your Honor.
Does that mean he has to say guilty? He can't do no?
No, he can plead no contest, Your
No
Honor.
contest
He would
is
just
the
be
same.
adjudicated guilty on his record.
So if he says no contest, there's still, it says there's an adjudication of guilt on the record?
Yes, Your Honor.
He's just not admitting to it.
Oh.
So it's credit time.
223?
You can get out.
223 are court costs if you're so inclined.
Okay, so.
Lamphere. Mikazuki. Zuski. Zuski.
Sorry, Judge, you have me geeking.
Well, listen, you don't have to apologize for laughing at me. If people apologize for laughing at me, it'd just be a whole world of laughter or apologizing. I am like, change. Am I going through a change?
Thank you. All right, Your Honor, we're ready to proceed.
Oh, what you got to tell me there?
Yes, Your Honor, I have the entering a plea of no contest to the charge of disorderly conduct. The agreed upon disposition is an adjudication of guilt, court costs, and credit for time served.
Is that what AG says?
Yes, Your Honor. Adjudication of guilt.
CTS?
CTS is credit time served, and then court costs.
Okay. All right, so Mr. Nahart. I just really want you to be Bob Newhart. I'm sorry.
He's my cousin.
Oh, really?
Yeah.
Oh, that is very convenient. So, Mr. Nahart, is your date of birth August 21st, 1957? Okay. Are you a U.S. citizen?
Yes, ma'am.
If you weren't, I would have to talk about deportation, but I don't have to. So you have been charged with disorderly conduct. The maximum sentence is
60 days, Your Honor.
60 days?
Yes, Your Honor.
60 days. You've been offered the plea. Do you understand the terms of that plea?
Yes, ma'am.
And you don't have to accept it. Do you have any other questions for your lawyer?
No, ma'am.
Now, you owe $223 in court costs that you're going to have to pay within the next year. Do you understand that?
Yes, ma'am.
You going to be able to pay that?
I hope so.
Then, January the 20th,
January?
2023.
Oh, actually, well, that's an extra 3 days. Jerry, maybe that's extra 3 days is what's going to make the difference, and you'll be able to pay that. So, have you consumed any alcohol, drugs, or medication in the last 24 hours? Are you entering into this agreement on your own free will?
Yes, ma'am.
So, to the allegation that on January 26th, you committed the offense of disorderly conduct, do you plead guilty, no contest, or not guilty?
No contest.
You said back in January 26th.
Oh, January 16th, 2022. Okay, well, do not do anything wrong on January 26th. So I am going to accept your plea. I made the findings that are set out in your waiver of rights form. I find that you voluntarily entered into this waiver of rights, and I'm going to impose the sentence previously indicated. You have 30 days to appeal the judgment and sentence. You can file a written notice of appeal with the clerk. Counsel can be appointed to represent you on the appeal if you qualify. Do you have any other questions for me, sir?
No, ma'am.
Okay, thank you. And thank your lawyer.
Yes.
All right, thank you, sir. Oh, wait, no, wait.
Good one, Mr. Mayor.
That- Cooking with gas there. Are you Mr. Timothy Taylor?
Yes, ma'am.
Hey there. So we're here today on case number 2022 M079. You have been charged with disorderly conduct. I am going to appoint the public defender, and I find probable cause. Defense?
Yes, Your Honor, just one moment.
Sure. Today's the day.
Judge, these are your no contact orders from earlier. You can sign them.
Your Honor, we would just ask the state put an offer on the record. Mr. Taylor's interested in resolving it.
Talk to us, State.
Yes, Your Honor.
Mr. Mikazuski.
Thank you, Your Honor. The state would offer an adjudication to guilt, credit time served, court costs on this case.
That's what you want to do? Okay. So, sign. Yes, Your Honor, we're ready to proceed.
Okay.
He'll enter a plea of no contest to the charge of disorderly conduct. The agreed upon disposition is an adjudication of guilt, court costs, and credit for time served.
Credit time served, adjudication of guilt. Okay. Mr. Taylor, is your date of birth December 17th, 1975?
Yes, ma'am.
You have been charged with disorderly conduct, which has a maximum sentence of 60 days.
Yes, Your Honor.
Look at me. You have received the plea offer. You don't have to accept it. Do you have any other questions at this time for your lawyer? No. Okay. So you'll be obligated to pay $223 by January 20th, 2023. Do you have any questions about that? I can barely hear you, by the way.
No, ma'am.
Thanks, I'm middle-aged.
Sorry.
It's okay. Do you, will you be able to make that payment, will you be able to pay that in the next year?
What's that?
Will you be able to pay that over the next year?
Not sure. See.
What? We'll see. What do we do with that defense?
But I should be able to.
Your Honor, you can reduce it to a civil judgment if you so wish, if he's not
Oh.
able to afford it.
Can I do that for the last guy, too?
If you wish to, Your
I'm
Honor.
going to do that.
Oh, well, I already did the paperwork saying that he got a year to pay.
I mean, it's not that I won't make the effort. I'm just homeless right now, so I don't know where things are gonna go.
Oh, thank you for your honesty. I'll reduce that to I will reduce it to a civil judgment. Do you have any objection, State, if we can do that for the last one?
No objection, Your Honor.
Okay. Sorry, now, see like how I waited to the end to become a pain in the butt? Okay. Because he had the same issue, and I didn't know that that was that we
Yes,
could
Your
do
Honor, I
that.
apologize, I should have brought it up earlier.
Don't apologize. Just remember that, let us know these things.
Yes, Your Honor.
Don't assume. Okay, so did you read and understand the waiver of rights plea form you signed, sir?
Yes, ma'am.
Do you have any questions about it?
No, ma'am.
Okay. Have you consumed any alcohol, drugs, or medications in the last 24 hours?
No, ma'am.
Do you understand what's happening today?
Yes, ma'am.
And that you, what you're agreeing to?
Yes, ma'am.
Okay. Are you a U.S. citizen?
Yes, ma'am.
So to the allegation that on January 16th, 2022, you committed the offense of disorderly conduct, do you plead guilty, no contest, or not guilty?
No contest, Your Honor.
Okay. So I'm going to accept your plea. I make the findings that, as set out in the waiver of rights form, and I find on a factual basis that you are voluntarily waiving your rights and that you are competent to enter into this agreement and that you have no further questions and that you're not under the influence of anything that would impede your judgment. And I will impose the sentence previously indicated. You have 30 days to appeal the judgment and the sentence. You will file a written notice of appeal with the clerk, and counsel can be appointed to represent you on that appeal if you qualify. Do you understand that, sir?
Yes, ma'am.
Do you have any other questions for me?
No, ma'am.
All right, well, thank you, sir.
Have a good day, ma'am.
You as well.
That's everything.
I think that's it, right?
Yes, Your Honor.
I have two that I